The 14th Amendment's Equal Protection Clause was added to the Constitution in 1868, but within 30 years the Supreme Court had handed down a pair of decisions that reduced it to meaninglessness. Those two decisions were Plessy v. Ferguson and the civil rights cases. This video focuses on the civil rights cases. While states like Louisiana were reinforcing discrimination by passing laws separating people on the basis of race, the federal government was trying to make life better for the recently freed slaves. Article 5 of the 14th Amendment gives Congress the power to create laws to enforce the Equal Protection Clause. Pursuant to Article 5, Congress passed the nation's first major civil rights act, the Civil Rights Act of 1875. The Civil Rights Act of 1875 regulated what is known as private racial discrimination, that is, racial discrimination by private individuals and businesses. The law made it illegal to discriminate on the basis of race in public transportation or other public accommodations such as theaters or inns. But several owners of white-owned businesses filed lawsuits, which made their way to the United States Supreme Court. The court consolidated the various appeals and decided them in one decision that has come to be known as the civil rights cases. In 1883, in an 8-1 decision, the court struck down the Civil Rights Act as unconstitutional. In their opinion, the majority focused closely on the text of the 14th Amendment. The relevant portion of the 14th Amendment reads that, "No state shall deny to any person the equal protection of the laws." The court noted that the 14th Amendment mentions states, but it does not mention private businesses or private individuals. As a result, the court concluded that the 14th Amendment simply does not apply to private businesses or private discrimination, and that Congress has no power to regulate or ban it. They said that the amendment does not authorize Congress to create a code of municipal law for the regulation of private rights, but only to provide modes of redress against the operation of state laws and the action of state officers. Just as in Plessy v. Ferguson, the entire court agreed, except for one justice. And once again, that justice was John Marshall Harlan. And once again, Harlan wrote a vigorous dissenting opinion. He said, "The opinion in these cases proceeds, it seems to me, upon grounds entirely too narrow and artificial. I cannot resist the conclusion that the substance and spirit of the recent amendments of the Constitution have been sacrificed by a subtle and ingenious verbal criticism." He continued, "I agree that government has nothing to do with social, as distinguished from technically legal rights of individuals. No government ever has brought, or ever can bring, its people into social intercourse against their wishes. Whether one person will permit or maintain social relations with another is a matter with which government has no concern. But, what I affirm is that no state, nor the officers of any state, nor any corporation or individual wielding power under state authority for the public benefit or the public convenience, can, consistently either with the freedom established by the fundamental law or with that equality of civil rights which now belongs to every citizen, discriminate against freemen or citizens in those rights because of their race. The rights which Congress, by the Act of 1875, endeavored to secure and protect are legal, not social, rights." But once again, Harlan was on the losing side. The court's opinion established what came to be known as the State Action Doctrine. Under the State Action Doctrine, the federal government only has the power to combat discrimination by state governments, not by private individuals and businesses. This decision created a legal conundrum for civil rights advocates. The federal government wanted to pass laws to protect African Americans from private discrimination, but the court said it was not constitutionally permitted to do so. On the other hand, the states had the power to ban private racial discrimination if they wanted, but most of them had no interest in doing so. And, in fact, many of them were passing laws to reinforce rather than combat discrimination. Therefore, private racial discrimination continued and increased. With Plessy v. Ferguson and the civil rights cases, the Supreme Court's destruction of the 14th Amendment was complete. Despite the amendment's promise of equal protection of the laws, the court held in Plessy that states could segregate people on the basis of race. And it held in the civil rights cases that the federal government could do nothing to combat private racial discrimination. The court's dismantling of the Equal Protection Clause took less than 30 years, and it would be more than half a century before it would start to repair the damage.